ang Kababayan today, helping viewers not just to survive but also to thrive here in the U.S. Although dito po sa Amerika, it's difficult to survive if you don't have your immigration status in order. And so that's why on the show we have our twice a month immigration update for you.
This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Welcome, Mr. Attorney Richard Lowe. Welcome to Kababayan today.
Good to be here.
All right. Now, a question from a viewer, and this will give birth to our discussion this afternoon. We had our interview at the U.S. Embassy in Manila last November, but sadly they refused to give us our visa because our petitioner, our grandfather, is still in the Philippines, and my father is the principal beneficiary. How do we overcome this issue? My grandfather is 90 years old enough to go back to the U.S. What do we do now in order to get our visa? I don't quite understand the question.
Well, this is actually a common issue with derivative beneficiaries because the petitioner is always the person that has to do an affidavit of support. Okay. And that affidavit of support has to be from the person that's living in the United States. So even though the principal beneficiary is now living in the United States, you still need to provide an affidavit of support from the original petitioner, which is the grandfather. Which is a 90-year-old
grandfather. And because he's in the Philippines, and I'm thinking that he's not earning any income here, he won't be able to provide affidavit of support.
That's correct. The petitioner has to be living in the United States or show his intent to be living in the United States. In this case, it's probably, unfortunately, the grandfather is going to have to return to the United States, and I would suggest staying there for maybe 6 months and then starting that process over again with the embassy.
Okay. Well, so this is in a way having your petition denied. But just in this case, you're saying that when your petition gets denied, it's not the end of the world because there are other ways that you can explore. That's
correct. Especially at the consulate, they usually don't deny the petition. They're just dealing with inadmissibility issues. And so those you can definitely go back to, once you've addressed those issues, go back to the embassy and start the process again.
All right. And so we have tips for you this afternoon. Actually, Attorney Richard Lowe has tips for you this afternoon on what to do, how to move on after a petition is denied. The first one is, make sure you remember this, this is not the time for do-it-yourself.
Yeah, you know, we live in a DIY, you know, mentality these days. Everything you can do it yourself. And sure, there are some things in the immigration realm you can do yourself, but once you get a denial, I think that's really time to get professional help so that things don't go completely off the rails.
Right. Some people do that. They do it yourself, petition, you go online, and they think that they just follow everything online, submit everything online, it's fine. But once it gets denied, you're right. You know, at least that's a time to consult an expert.
Yes, right? make sure that you know what the next step is going to be and those steps are taken.
And the next step is usually to make an appeal. But I'm understanding that it's also a very complex issue because there's different avenues to which you should make an appeal.
Right. It depends on what kind of petition was filed, whether the petition or the application is being denied. So it could be a direct appeal, for example, to the Administrative Appeals Office. Sometimes it has to go directly to the BIA, which is the Board of Immigration Appeals. Sometimes applications have to be just appealed in immigration court when you go back into court.
And a lawyer can tell you that. Now, here's just an example of how convoluted it can be. Rogelio is a U.S. citizen who just married Evelyn, who has no status and entered the U.S. using an assumed name. They file a petition for alien relative, an application adjustment of status, and a waiver application for the fraud that Evelyn committed at entry. Letter A, if the government approves the petition but denies the waiver application, then you need to file an appeal with?
Well, if you're talking about the denial of the waiver, then that's the Administrative Appeals Office. And what's important to keep in mind is that although you're doing this all at one time, there's really 3 different things going on here, so they each go to different places. So if the waiver is denied, that has to go to the Administrative Appeals Office.
Okay. If the government denies the petition, you need to file an appeal with the Board of Immigration Appeals. So that's a different one.
Yeah. So in a marriage situation, if your petition is denied, you go directly to the Board of Immigration Appeals to do that appeal.
All right. And we keep saying denial, but you're also saying in your tip number 3 that not all denials are equal, meaning sometimes it just takes for you to refile. So what is the difference between refiling and making an appeal? When do you use one or the other?
Well, in certain situations, for example, the marriage case, if we would come into this case late and the facts that were presented to the officer at the time weren't that strong, the documents weren't that strong, and now we're in an appeal process, it may be better to start the process over again and get a better record in front of the officer, so that if we have to go to appeal, then we're appealing on a better record. Okay. So if the record is not strong, sometimes it's better to start the process over again. Sometimes it's sufficient just to go to the supervisor and say, look, there was these mistakes made, these documents weren't turned in, what can we do about this? And oftentimes that might be successful. And
a lawyer is needed in order to review your particular case. Call that number on the screen now to schedule your consultation, and don't delay, because step number 4 is time is of the essence.
Absolutely. In an appeal situation, you normally have 30 days, and that's from the time of the decision. So you cannot dilly-dally with an appeal, and it's important to get that done immediately. So if you haven't heard, if there's an issue in the case that you think something's going to be a problem, then you need to really be on it so that you don't miss the appeal window.
And Aquino and Low Law Office can take care of that for you. That's information on the screen. Call now to schedule your consultation, either via phone or online as well. They also have, they also make their services available to our viewers joining us on Kiku Network in Hawaii. Thank you. More power to you.
Thank you.
More when we return on the show. Don't go away.